Welcome back to another legal update. Today we're talking about our appeal on a defamation case we had against Newsweek, an appeal that we were ruled against on, and I find it egregious. And this is a topic I hardly know where to begin on this one because there's a lot of history leading up to this defamation
back to
suit
another
and
legal
this ruling.
update.
But I
Today
think
we're
one of the
talking
first things I
about
should
our
say
appeal
is
on a
that
defamation
people
case
often
we had
think
against Newsweek.
that
An
when
appeal that
we say
we were
somebody
ruled
has the free
against
speech
on,
right to say something that
and
we're
I
advocating
find it
for what it is they say.
egregious.
And oftentimes that's not true. We stand by the principle of free speech. And then some people don't see how that applies when we're talking about defamation, threats, those types of things. But I think in order to understand our position, people need to understand what the status quo has been of First Amendment free speech, free expression law for a while now. And our position is pretty much in line with the understanding of the court, we think, for the most part. Legal history up till now, I think has been pretty good about free speech standards, and free speech has been, I feel, under attack for some time now at the political polarized ends. But when it comes to things like claims being made, factual claims, not matters of opinion, but factual claims that can really damage people or our organization, we have a duty, I think, to defend ourselves on those things and show people that those are false so people don't feel that the membership who are affiliated with us are affiliated with some kind of nefarious organization that is doing things that aren't. In those cases, it's not just well and good to say, well, somebody has their matter of opinion as to whether we're a criminal enterprise doing these very specific things we're being accused of. Those are things we can't stand by. So this goes back to October 2021, and just in time for Halloween, as they put it, Newsweek published a hit piece against the Satanic Temple that was authored by an old school satanic panic monger by the name of Julia Dean, which is, I believe, how she said her name is pronounced. It's spelled Duin. And her previous works included a book called Purity Makes the Heart Grow Stronger, which the Library Journal claimed makes the case for chastity with insight and sensitivity. The article she ended up writing about the Satanic Temple would make false claims of sexual abuse and cover-up within the temple, leading to our defamation suit. In suing Newsweek for defamation, it was not enough to establish that the claims were false or that they were lacking in any evidentiary basis, because if that were the bar, we met it right away. But we needed to prove that they had engaged in actual malice, meaning that we had to prove that Newsweek had, quote, quote, knowledge that the allegedly defamatory statement was false, or they acted with reckless disregard to its truth or its falsity. And I guess as we talk about this, we'll see how vague that is, because with this ruling, I can't understand what we could have actually done to have proven malice, because all we got was a ruling that was saying that essentially nothing was enough. The fact that there was no evidence for the claims published was undisputed by the time the court ruled. The question was strictly whether or not the publication of the false claims constituted actual malice. And this goes back to, we had a group of members in our congregation in the Pacific Northwest during 2020. And if people don't understand the model that TST had been based on, we gave the chapters, later the congregations, pretty much full autonomy. They sign on, they kind of have a licensing agreement with us where they use our brand, and they have to act within certain parameters. But as to what they do, we weren't telling them what they could or couldn't do beyond what they signed on for when they came in. So all of a sudden, we had this group of people who left our Seattle chapter claiming that we were guilty of all kinds of nefarious things. And I had never had communication with these people. I didn't know anything about them, but they weren't talking about disputes they had within their chapter. They were mostly talking about me. and they were mostly talking about the national management of the organization, which they actually had zero interaction with. And they were trying to appeal to far left online types uh, who immediately felt obligated to respond if they said we were of a fascist bent or crypto fascist or whatever, and trying to find these hidden nefarious right-wing agendas in the things we do, which was funny because then we looked into these people, and amongst their initial group, one of them was already in litigation for beating their wife. Another one turned out to be a straight up racist, as shown by somebody who came forward and published texts of theirs that they had sent. And they ignored that. They kept him within the group. Some guy named Heinrich, who I guess they later kicked out for reasons completely unrelated. And they called themselves Queer Satanic, and they used a little logo that utilized somebody in a wheelchair or whatever, which I think they abandoned when they ran into criticism for, I think none of them had any disability. And as to whether or not any of them actually identify as queer, who knows? But it's something that gets people on board and makes them feel like they need to, they need to fight whoever the opposition is, the supposed opposition is to wherever their positions are. If they raise the louder voice claiming that they're representing the marginalized for their own benefit. But in any case, it turned out that somebody from Catholic News Agency had reached out to this Julia character at Newsweek, essentially pitching a hit piece against the Satanic Temple. Why a Catholic News Agency didn't want to do it themselves is probably because they figured these weren't credible people. I mean, these are people who, for the past 6 years, since 2020, have tried to collect every negative thing said about us online. There's a man claiming to have been an unrecognized co-founder of TST who said I was working with the CIA. They met up with him. I had a mentally disturbed by her own description stalker who they were also reaching out to. It's just they'll collect every kind of negative thing about us, and anytime anybody's has done a bit of investigative journalism, they've come across them, and I've talked to some of these journalists who feel that these people are clearly clowns and aren't to be taken seriously. So it was alarming when Newsweek decided that they would do whatever they could to publish a hit piece and even use these bad sources. And even then, they started out, and they were obviously interested when Newsweek interviewed me through Julia Dean in trying to prove that there was something financially nefarious in what we were doing. And Queer Satanic, for their part, they were claiming that we were a pyramid scheme, whereas they never defined what that was supposed to mean, and it couldn't have really meant anything from a financial perspective, because another thing from how we were organized is that we weren't taking dues from anybody. We weren't tithing. People were coming in and they were running these congregations and things like that, but they weren't paying us anything. So the idea of us being a pyramid scheme was weird to say the least, but their idea of that would be that any organization is a pyramid scheme so long as it has a hierarchical infrastructure in which somebody is top management and there's other people working at lower levels. So I was being asked a lot of questions about our different holdings, our different legal entities, which may seem confusing to people on the face of it. We have United Federation of Churches, we have Reason Alliance, and we have these other entities, and people wonder why. What are you hiding? It's not that we're hiding anything. It's just that we started out, we weren't tax exempt, so we started an LLC. Then we needed a nonprofit to run things like the After School Satan Club, so we started a nonprofit. Then we got our religious tax exemption in place, which necessitated us having another business entity set up. So we end up with these entities, and it's just a matter of process. So after a while, when I was being asked about these things, I eventually asked the journalist, "What do you think is going on here? What is even the scam here? What do you think you're revealing? I mean, I've told you everything I can about why these entities exist." So she abandoned that, but didn't interview me again, and then just decided to go with another story in which these claims were made that I was never given an opportunity to reply to. Now, here were the defendants. I have, I think, what are the relevant pieces of text from their depositions. And these are all the defendants who claim to have interacted as members with the Satanic Temple and were claiming that they were disclosing or whistleblowing this idea that there was sexual abuse that was being covered up within the temple. There was this person, Nathan Sullivan, who was asked in deposition, are you, and you personally did not see any of the sexual harassment, correct? His answer, correct. There was somebody, Paul Millerons, who went by the also known as Jinx Strange. The question was, okay, is it fair to say that your understanding of sexual abuse was secondhand through people basically telling you something over the internet? His answer, yes. And it was Millerons who was quoted in Newsweek as claiming that there were accounts of sexual abuse being covered up in ways that were more than anecdotal. And we found out it was less than anecdotal. We couldn't even find the people these anecdotes were being attributed to. And this is after the discovery process and after Newsweek had every need to find these people and come up with credible claims. I'm sure they were nervous that they would actually lose this case because I feel they should have. So they did thorough investigation of their own. And believe me, if they came up with a fucking thing, you'd know about it. David Allen Johnson, he was another one. Okay, have you personally witnessed any sexual abuse within the temple? Answer, I have not. And then Nancy Cooper, who was the global editor-in-chief for Newsweek, she was asked, Julia Dean wrote articles for Newsweek, correct? Her answer, yes. Did you fact-check anything in the articles? Her answer, no. I raised questions to her, but I didn't personally fact-check things. Question, did Julia fact-check anything? Answer, I don't think so. Question, and we're not talking about just this article, we're talking overall. And her answer, as I recall, yes to what you're saying. Did anyone else ever go over Julia Dean's entire career at Newsweek, fact check any of her articles? Answer, I don't think so. And it goes beyond just bad journalistic ethics in general, because Newsweek published on their own site, I think they might have removed it now, but they had their own journalistic standards published on the site, which claimed that they did fact check these things, that they did go in to make sure that they weren't publishing unreliable hearsay and other such things. So we felt that this would give people the impression that this article was fact checked in the way that they claim it is on their own site, and that people would then feel that they could reasonably believe that there were, in fact, claims of sexual abuse that were being covered up. In fact, there were claims of claims, and the claims never actually manifested, even after intense investigation. So we thought this was a pretty strong case. And this question of actual malice seems rather subjective to me. The original court did not seem, the original ruling, I think, when we went to try, not to trial, but we did the oral arguments, because it never went to trial, I didn't feel that the judge was really leaning in favor of Newsweek. She seemed very critical of Newsweek, and Newsweek was trying to give these technical arguments in favor of this actual malice interpretation that would say that they weren't guilty of actual malice. They were just kind of quoting other people, and they didn't have reason to believe that these things were false. And we felt they had every reason to believe these things were false. If we looked at the behavior of the people they were talking to, if we looked at the limited scope they had set and the very limited amount of people they had spoken to, and just the fact that they put blinders on and decided to claim ignorance, that they didn't see anything that would disprove their claims, didn't seem like a strong enough argument, at least to me, to claim that the burden of proof had been met to establish actual malice. But that's what came back. That's what came back to us, and that's what the eventually the appeals court even said, is that we just did not establish actual malice. We were not able to crack into the skulls of the people responsible and show beyond any reasonable doubt that they acted with malice towards us. All we could do is point to the malice they had exercised against us traditionally in the past, their convenient ignorance of the facts around them, their obstinate refusal to look at anything that might disprove their claims. But that wasn't enough. So I guess I don't really even have an opening question so much as to ask for initial thoughts as to what you both think as lawyers went on here. Like, what my question in reading over the ruling at this point is then what is actual malice? We were only told, that all the things we showed did not establish actual malice, but nowhere in the ruling did I see anything that said what we could have done to establish actual malice unless sitting somebody down, putting electrodes on their nipples and making them say, yes, we acted with actual malice, similar to the cases in which we have been found that we haven't shown we were discriminated against, even though discriminatory intent seemed to have been solidly conveyed from the opposing parties. But it seems to be that without an explicit statement of intent from our opposition, we're left with nothing at all. Is that the case, or was there some vital component that we missed?
That is the case, categorically and definitively. This is the shit that we deal with day in and day out with our civil rights cases. And you know what? If the fucking First Circuit wants to look the other way while the city of Boston makes a political question about our religious equal rights, that's, you know what? The Establishment Clause doesn't mean anything, so whatever. Um, I got a problem with it when these are not civil rights, these are just property rights. Your right to a defamation liability is a property right that's different from a civil right, which, for reasons unclear to me as a lawyer, are treated differently by the federal judiciary, at least for the past 40 years or so. Maybe we'll start seeing things differently in time. But as it stands, our civil rights are given a second class status. Um, my first impression, which irritates the hell out of me, is I'm screaming into the void. I want to share my screen and just kind of take some notes on some highlighted comments that I have. Let's see here. Is that the wrong one? There we go. So I want to take note of a few comments that I have just quickly off the cuff here. First of all, this notion that we have to beat a confession out of a defendant as to get to a finding of, okay, yeah, we can get to actual malice jury question. Boom, right here, Ninth Circuit. We've yet to see a defendant who admits to entertaining serious subjective doubt about the authenticity of an article it published. When you're at the summary judgment stage, I confronted the Second Circuit. This is my Second Circuit brief. Uh, we confronted them very clearly. You don't need to beat a confession out of the defendant. Just because they say, I believed it, doesn't mean they get summary judgment. And that's not just the Ninth Circuit. We were in the second. It's also the Second Circuit. A defendant will rarely admit it. You're supposed to look at the circumstantial evidence. Uh, Here we have this notion of the editorial guidelines. A core part of our argument in this case was that it's not just that they should have investigated because any reasonable journalist would have. It's because their own publicly broadcast standards say, we investigate this, we have to investigate this, and we didn't in this particular instance. Now, binding Supreme Court law says when you conscientiously avoid an investigation, when you're purposely avoiding the truth, that tends to show that you believe that the thing that you're saying is false, and that if you look into it, you're going to find proof of falsity. So if you just pretend to be ignorant about the matter, well, then that's good enough. Well, no, Supreme Court says you can't do that if you're
I mean, the
conscientiously
degree to
avoiding
which
the truth.
ignorance was taken as a legitimate excuse here, to me, seems insane. The idea that, well, I did as much as I could to limit my scope of information and to take in as little as possible information from the other side. It seemed like they were arguing uh, in defense of their lack of journalistic ethics by pointing to their lack of journalistic ethics. Like, I feel like that's the nature of being a journalist and putting out a credible report is asking for any oppositional viewpoint that might exist. And their excuse for their behavior was that they hadn't done that.
And I would agree with you as to Newsweek, but I mean, it's Newsweek. Obviously, they got to say something. They can't just show up to court and be like, ah, fuck, they got us, right? My problem is with the judiciary. I made it abundantly clear. Newsweek conscientiously disregarded their own standards. This speaks to recklessness. This is the difference between recklessness and negligence. 3 pages. I go on and on and on about the law and the facts of this is what the difference is between recklessness and negligence. What do they say? Right here. They deal with it in half a fucking clause. TST's argument sounds in negligence. Fuck you. We don't feel like dealing with your argument. This is what I deal with day in and day out with these goddamn civil rights cases, which, again, civil rights, second order class of rights, whatever. But when it comes to a standard order property right, defamation, this is abjectly infuriating. I make the arguments, I provide the citations, I explain this is exactly what's going on in great detail. And what do I get in response? Half a fucking clause of fuck off because we said so. That's my chief takeaway here. And I can go on, but suffice it to say, there's a lot more of it.
Well, one of the lines that stuck out to me in the appeals ruling too was that they gave the journalist a pass by saying that this statement, I mean, even admitting that there was no evidence for the claim being made, because they certainly didn't want you arguing to falsity. I remember a judge stopping you during oral arguments on the appeal and saying, "Well, you're not arguing for falsity," because they wanted to make sure that the truth of the claims being made were not at issue here. They didn't want to hear it. But in the ruling, it says that about the claims, the more than anecdotal sexual abuse claims, was something that the journalist corroborated with other sources. And I feel that's an abuse of the word corroboration. It's like you don't go through the same group of people who are in unison asking for an interview together to defame you and say, like, well, the three of them agreed on it, so that's corroboration. That's not corroboration.
I agree. And here, let me show you exactly the quote you're referring to. Um, Here it is in so many words. I showing the right screen. Yeah. Strange's report of accounts of sexual abuse being covered up in ways that were more anecdotal was corroborated by multiple other sources. No, it wasn't. Dean specifically testified that she didn't so much as ask a follow-up question about what sex abuse and cover-up even means. Didn't talk to anyone, didn't ask for any individuals' names, didn't even ask what sex abuse and cover-up means. So, again, this is the shit that we deal
Yeah,
with. It's like the
we
judges just say, fuck, I don't know. I feel like she corroborated because two people said the same rumor, and therefore the rumor must be true, right? No, that's not how it
right.
works.
Well, more than one person said it, and that's what they mean by corroboration. I don't feel like in any legitimate field of inquiry is that considered corroboration. But the first question we got from somebody was the Newsweek article ever taken down? And no, it wasn't. It's up there, and it has something to do. It has orgies in the title. Like it claims it gives you the impression that there's all kinds of sexual abuse happening within the Satanic Temple, and this was something obviously the Catholics really wanted to get out there about us. Just because they always like to hold a mirror up against their own problems. And I mean, in the article itself, I think you can see the hostility of the sources. They claim they had joined the Satanic Temple without even identifying as Satanists. They never even identified with Satanism to begin with. They just thought the activism was cool or whatever. And I guess they wanted to just, I mean, they started out by stealing our social media assets, the Facebook page, and then use those to defame us and things like that. And it went on from there. And like I said, they have a whole history of just actively harassing people within the Satanic Temple, defaming the Satanic Temple. Just these are people who've gone out for 6 years doing this without being able to articulate a direct claim of anything that actually happened to them. So I feel like it was kind of our lax standards, perhaps, on membership that people came in most likely with the intention of doing exactly what they did. The case, the Newsweek case, was litigated in New York, which is where I think these actual malice standards aren't unique to New York, but are particular to New York in any case, which is to say that some other state might not have had these standards. Is that correct, Matt?
Yeah, so actual malice is a First Amendment concept. It started off with the idea that a government official, if he's going to sue someone for defamation about their government conduct or really anything, he's a public figure, and therefore, there needs to be a wide breadth for people to comment about our publicly elected officials, right? It's a democracy. We got to have a wide range for democracy and the free exchange of ideas, particularly as pertains to our own system of self-government. And that makes sense. But then it kept getting further and further and further pushed out where, okay, well, maybe if you're like a general purpose public figure, meaning you're, I don't know, a celebrity, for example, a household name, well, then same, fair enough. You invited the public spotlight. Well, then it said, okay, well, if you're involved in certain kinds of public advocacy and it's about the public advocacy that you're involved in, well, then that's fair. Well, New York took it the next step further and said, well, actually, if it has anything that the general public might have some passing interest in, well, then you have to show actual malice. This is a matter of statute. It's not a matter of the Constitution. Um, there was a brief, like 5 year period in which that was the First Amendment law. And then in a case called Gertz, the Supreme Court said, no, that's actually an awful idea. We're not going to do that anymore. It has to be about the issue itself. You have to be a public figure, or you have to at least be a limited public figure, which is to say, for example, TST, anything that we do that's within the scope of our public advocacy, we're a limited public figure. Otherwise, we're a private figure and you have to show mere negligence, not actual malice.
What do you make of all this? You've been awfully quiet.
Well, I didn't have anything to do with this lawsuit, but here's my thoughts. I've been screaming from the rooftop since the beginning that from a big picture situation here, the Satanic Panic never ended. And to me, this is squarely a Satanic Panic lawsuit where we've got people. It's a tale as old as time, right? Where you got people that claim to be former Satanists or insiders. I saw what goes on inside a satanic group, and you've got the same old tired accusations of what almost equates to satanic ritual abuse or some kind of strange dealings that always comes down to some kind of like you said with the article title orgies and all this stuff, really sexy headlines that it makes. And, no one ever apologized for the Satanic Panic in the 80s and 90s because it never stopped. And I just feel that it's baked into American culture, where when you have a group like this, and then there's a accusation of strange dealings behind the scenes, whether it's financial or sexual or, you know, animal sacrifice, you name it, people just take that as well, yeah, of course. No one has ever proven any type of satanic ritual abuse, and it's the same in this case. Nothing that's ever accused, no, nothing a satanic organization is ever accused of is actually true. But I think it's baked into society that, even like the QAnon or the Epstein stuff, it always comes down to it's a satanic cabal or what have you. And that's what we have here. And then also the standards between negligence and reckless. This is what I have a problem with legally with the ruling is that the concept of negligence is you didn't know better, but you should have. And the concept of recklessness is you did know better and you did it anyway. And I think that's what you have here when you have an organization that didn't follow its own journalistic standards. They had journalistic standards. They didn't follow them. They know they didn't follow them. How is that not reckless? So that's where I have a problem with it legally. But I really do think that what it all comes back down to is this is satanic panic stuff. This is what everyone's expecting to hear about us. No big deal. This is just another, crazy satanic group with sex scandals and money scandals. And I just think it's completely normalized.
Yeah, well, it needs to be said that Julia Dean herself wrote many a satanic panic article, straight up old school satanic panic about the idea of satanic cults, cannibalizing and other such things. I mean, she was right in there. And these people who fashion themselves queer satanic, they even did a joint presentation with her at some conference in Seattle. So working right alongside her. And if you know, uh, if you know the how the depositions went, I think you would see how absurd this got and how desperate Newsweek became for any evidence of actual sexual abuse and cover up. This David Allen Johnson guy, who's part of this queer satanic group, he went so far as to he was far reaching. So he claimed that this hashtag nude for Lupercalia thing that happened on my Twitter account could constitute sexual abuse. And what happened there was in a I had left a post on it was Twitter at the time, something about Lupercalia, and people of their own free will started leaving nudes in the nude pictures of themselves in the comments thread with the hashtag nude for Lupercalia, and it kind of caught on, and I did encourage it. It's like, go ahead, and people started posting, and of course, all of a sudden, this guy's tender sensibilities were just all offended, and now this was the kind of puritanical view of what sexual abuse could be for lack of having anything else. People of their own free will leaving nude pictures of themselves, which I think they felt was empowering or sex positive or whatever else. But in desperation to find something tangible, this is the kind of shit they dredged up in the depositions, which to me shows you how asinine and frail this case they had was. And it's also, it's just, but it's horrific. Then you lose this kind of thing. And as we're told in the chat, Reason Magazine's headline is "The Satanic Temple Loses Libel Suit Against Newsweek Over Accounts of Sexual Abuse Being Covered Up." And it's like, that doesn't do us any favors either. It would be helpful if they mentioned against like completely unsubstantiated claims of sexual abuse and cover up, but that's not what we get. And that's what I think is the real injustice here, is kind of the Cliff's Notes version people get. The one line summary is that we lose a defamation suit where people are claiming sexual abuse cover up. I think in their minds it implies that it's established that there's some factual basis for the claims. And I think that's something that should be more present in the court's evaluation than it is. And I mean, again, my question remains as to what could have we done to establish actual malice? What was there anything in the ruling that even indicated what they were looking for? Because if there was, I missed it.
No, there's nothing in the ruling about, oh, well, if only you had shown X, you would have gotten there. This kind of goes to the nature of courts, unfortunately. We are still dealing with people. It is still politics. This is literally government advocacy, what I do on a day-to-day basis. And what we're dealing with here is we were playing Calvin ball. No matter what we did, no matter what we said, we were getting tossed out. That's going to happen. I showed some of the examples. Suffice to say, there are several more about we show, look, the issue is not about the pseudonymous nature of attributing the quote to Jinx Strange. The issue is that Jinx Strange's comment was based clearly on hearsay. He expressly told Julia that this is hearsay that I'm passing on, and she published it as if it was true. In Newsweek, more than 1 in 5 Americans read us. Newsweek magazine, that one. And there's not a nary a fucking mention in the entire opinion. Nothing we did would have gotten us there. That is the irritating thing that I have to deal with in the course of what we're talking about here. Nothing we did. Nothing. I could have beaten a confession out of them. They said, oh, well, fuck. I mean, she said that she had actual malice, but did she really mean it? I don't know. That's not a jury question. That's going to be something that we have to throw out. It's impossible.
Somebody asked, and this is a kind of question I previously would wonder the answer to myself, but now I've become a bit more jaded, and I feel like the answer is, my answer is very unsatisfactory. But somebody asked, what are some of the consequences of this ruling in terms of the precedent that was set? And typically, I would say I would have thought this sets a terrible precedent. And now they're pretty much saying that news outlets can lie about anything and even lie about the journalistic standards that they hold to reach the kind of conclusions that they publish in the most defamatory of ways. But I think in reality, and you might disagree, this is a precedent that isn't really a precedent. I feel like it's a ruling that will apply to us, and the courts will treat a different plaintiff entirely differently when they're not the Satanic Temple at their whim, when the conditions are different, or when they're more, I guess, positively inclined to take the claim seriously. But maybe you feel different.
I do, actually. If they hadn't said, oh, well, this just sounds like negligence and negligence is enough and therefore you lose, then I would tend to agree. Or if they said we're going to designate this as a non-precedential opinion, this is basically just like a thing that we're saying in this particular case, and we reserve the right to change our mind later if we want to, I would tend to agree. This is a precedential opinion. This is designated for publishing. This is the law of the Second Circuit. And I searched high and low, state court, federal court, appellate court, trial court. I searched everywhere. There is no other case in which a publisher defied their own journalistic standards to publish defamation anywhere. This case is the first and only case that says you can do that. That's totally fine. We live in the age of disinformation. Beware what you read. Don't trust anything you read. And, what's the truth really? That is actually what this stands for.
That was what I was going to say is it's exactly things like this that essentially promote disinformation, where they're saying, it's in like similar to the civil rights cases where we actually have people on record saying we're going to do anything we can to stop this one minority group from doing something, and then our ruling is it wasn't discriminatory because I didn't say it in the right place at the right time or what have you. And I find the same with this where it's well, they can do whatever they want. They never said the words, I had actual malice when I did this, so it can't be proven. It can't be proven with circumstantial evidence. It can't be proven with their own internal standards that they didn't follow. We know that it wasn't true. That wasn't even part of the question. And to say that that's okay, yeah, it's exactly what Matt said, where it's like, well, this is the world we live in. You can't trust anything you read. What's the difference here? And how can you make a precedent out of that?
They didn't care about Newsweek not following their own standards. I didn't feel in the original ruling, but then in the appeals, I was a bit disturbed that the court indicated that they weren't aware of this fact when the oral arguments were being given. And I was disturbed, in fact, by how little the appeals court seemed to know about the case that was being argued before them, because Matt had to correct the judge, if I remember correctly, about the fact that it was their own standards we were holding Newsweek to. And the judge was apparently hadn't read the briefing and was under the impression that we had our own sense of what journalistic responsibility was. And I felt a lot more confident before the original court, the lower court, but then with the appeals court, I really got a feeling that they just didn't look over this case at all.
That's exactly the impression I got. I mean, look, I had the exact same feeling walking out of the I say walking out, God forbid it was COVID. Walking out of the Scottsdale oral argument. I was met with blank faces, like I took a shit in the fucking robing room right before oral argument. It was as if it was an affront that I was there to begin with, which is fine and fair in a normal appellate standpoint, but meaning I do a lot of appeals. I've probably got like 80 or 90 appeals under my belt at this point. That's pretty normal, is to be apologetic about, look, I did everything I could to avoid this place. But It's a uniquely different experience when the court doesn't even read the briefing, doesn't even read the record. I get questions to the effect of, well, didn't they look into this? No, actually they didn't. That was like half my fucking brief, is that they didn't and they were supposed to, and their own standards said that they were supposed to. Did you read any of this shit? So, it's uh going straight in the trash, which is not the ordinary course in appellate court. In trial court, fine, whatever. The trial judge is just doing whatever they feel is right. In appellate court, they're expected to read the briefs. They have an army of fucking clerks behind there showing up every day, reading briefs, doing bench memos, designed to create laws that are designed to tell the trial courts, this is how you're supposed to do things. This is how your cases are supposed to go. We desire that like cases are treated alike. But then, once you slap the name Satan on the case, well, all that shit goes out the window.
Yeah, somebody asked if we'll appeal this ruling and what's next, but to appeal, that the next level is the Supreme Court, and the Supreme Court is free to deliberate or not deliberate on cases as they see fit. And I feel like there's a 0.0000001% chance that they would take this one, even if they were inclined to set different standards for journalism than the asinine ones being put forward by this circuit. I don't necessarily see this Supreme Court doing that in a way that would be seen to validate the Satanic Temple. I don't think this is the one they would want to do this with. And, we have limited resources. We don't have a whole lot of money to experiment when it comes to lawsuits like this. And putting together a brief, I think, for the Supreme Court would be time consuming and expensive, and I think it would come to naught. So, our solution here is just to kind of talk about this openly, talk about, how these depositions went, just let people know that no, actually it came out, in the investigation in the course of this trial, we can clearly see that there were no actual claims of sexual abuse that anybody was talking about, and that's not even what the case ended up being about. It ended up being about these, at this point, I feel, ill-defined standards of actual malice that we're still left scratching our heads trying to figure out how we could have met this burden of evidence. And it's just not clear at all. I think, others might have different opinions about the worth of trying to take this to the Supreme Court, but my strong feeling is that we wouldn't hear anything back about it. I think we would just get a no thank you, or whatever formal no that we would be obligated to receive, I think is what we would get. I don't know if you guys feel differently about that.
I'll say this.
I don't think.
Go ahead, Stu.
I don't think they would take it. I mean, I don't think they need to take it. It's this would be an uphill battle for us, I think, if we appealed it in a essentially hostile forum. Also, I don't know if you feel the same way, Matt.
I could not agree more. I'll say this. Your average appeal, you have about a 20% chance of reversal. Your average Supreme Court case taking it, it's called certiorari, is about 2%. That's them taking it. You're entitled to an appeal. You're not entitled to the Supreme Court looking at your case. About 2% of cases receive that view, number one. Number two, I don't know what the stats are once it's been, what's been taken up, whether it's reversed or not. But, it's the rare case. What they're usually looking for is a circuit split. Or, if it's not at least a circuit split, it's like there's internal dissent within the court that took it up to so for example, you have the Second Circuit. This is a 3-0. We lost 3-0. We could theoretically take it up to en banc, which is to say we want more Second Circuit judges to look at it, but that's going right in the trash bin. Look, they're not even fucking addressing my arguments, all right? We're not dealing with good faith actors here. So it's going to be a waste of time to ask en banc. It's going to be a waste of time to ask Supreme Court. So I agree with you wholeheartedly, Doug. This is the one.
The ruling itself seems like it's talking out of both sides of its mouth too. Like it says that it's in the public interest that questions of our social integrity be asked. Whether or not we're committing sexual abuse is in the public interest to know. The court agrees on that. And yet the court seems to feel like there is no responsibility for an accurate answer on that. And I feel like at that point, it's how can you even use the public interest argument if you're going to say that a question sans its answer or, given a false answer doesn't matter. Just the question itself is important enough that you allow it to be asked and inappropriately concluded through false evidence. It's like it really seems it's not often I read a legal ruling and feel like there's just such a tremendous amount of bias in it in that way, where it seems like all the evidence is being marshaled towards one conclusion, even to the point where it's a bit ridiculous. And I do think that standard is ridiculous to say, okay, this is in the public interest, but not necessarily whether the answer to it is accurate or not. And I feel like I mean, is that a novel bit of idiocy in this ruling, or do we commonly see that kind of stupidity based on just natural outcomes of a very narrow technical view of certain standards of evidence?
I feel like it just justifies kind of, I mean, it's the zeitgeist, right? It's like we're living in dumbass world right now, and here's another example. We can't expect people to not act negligently. So if they do find out it's negligent, you mean it's like, well, they acted negligently. That's not enough. That's kind of standard journalism is acting negligently. That's kind of how I feel that this shakes out, where journalistic negligence is just the way it is now.
Well, I think the ruling even said that, I think, straight up. I think it used the word negligence too. And I think the ruling even said that this may have been negligent, but that does not mean it's actual malice. And I feel like they did everything they could to take everything away from an argument of actual malice, to the point where, like I've said again and again, I just don't know what's left. I don't know what's left to establish actual malice. If this isn't it, what the fuck is, And like you said, like Matt said, regarding Scottsdale, that was the similar frustration, that there seemed to be nothing we could do to prove discrimination beyond somebody saying, you know what, I've defected from my own side. I engaged in discrimination. That seemed to be it. Like you needed a full confession from somebody, or that was the case. And I feel like that's the case on this one. Sure, they might have been lying, they might have been negligent, they might have been defying their own journalistic standards. They might have put a journalist on the case who had written satanic panic articles, who was, implored by somebody from Catholic news agency to straight up write a hit piece about the Satanic Temple based, prior to investigating it or anything else. They had chosen their interview subjects as people who had written negative things about us and posted them all over online. The idea was talk to these people and write an article about it. All of these things converge into, I think, very open, calculated malice. And yet that just was not found to be the case. The court would not see it that way. And I just don't think there's any way they would.
And now it's a double whammy, right? Because those kind of headlines, it doesn't say despite no evidence of sexual abuse being
Right.
covered up. Despite that, the Satanic Temple loses the libel suit or defamation suit. No, it just says the accounts of sexual abuse being covered up. They lose about that issue. So it's a double whammy. Now it doesn't say in the headlines that there was no evidence of this, that we know this wasn't true, and in the fact of that matter does not exist or does not matter for this libel suit. That's not what the headline's going to say anything like. It's just going to bring up again sexual abuse being covered up. That's the headline. It doesn't say anything about the truth
To
of
be
that.
fair, when we got the last ruling from the lower court, I felt that the articles that were written about it seemed to, even though they were mostly neutrally written because they were legal reporting, I did get the tone from those articles that they felt it was a bit much. That the court was saying that there was no evidence of actual malice, and that this seemed to be a new understanding of what malice could be, essentially being something unprovable, unless, like I said, there was something explicitly, stated from the defendant saying that, yeah, malice was the case here. Like when a guy uh, lit our place on fire, our headquarters, and when the police grabbed him, he said, "Oh yeah, it's a hate crime." Like, so, I mean, at least we didn't have to argue that one, but I feel like that was all we could have gotten from this. Uh, Somebody asked, what can we do to help? Would writing the company to remove the article help? I doubt it, but I don't know. Maybe you guys have more optimistic feelings about that, but I feel like at the point where they were willing to go through this litigation and stand by such a shitty article. I don't think anything anybody says at this point is going to be something that they won't just ignore. And I believe there's some anecdotes even from the depositions. I believe the editor, the global and chief editor, Nancy Cooper, she gave the deposition on behalf of Newsweek itself and her own personal testimony, and she seemed very worried about the outcome of this case and about her own responsibilities. And what was she not stress puking by noon, Matt?
She sure was. That's one of my favorite anecdotes, actually. I had the global editor-in-chief vomiting up her coffee. She didn't even have lunch yet. About 11 a.m. Because, we had her dead to rights. We had her uh, email by email telling Dean, I want you to inject this specific point that is not here nor there at this point. Uh, this thing that I know is false. And Dean was like, we don't have any basis to believe that that's true. And she said, put it in anyway.
Yeah, even Julia Dean was worried about the article carrying her byline with the. I mean, that's another thing. Like they didn't find actual malice, but we even and we had to press for these email exchanges. They tried to make them immune to discovery. They made an argument that these emails between them regarding the construction of this article were somehow privileged or whatever, and the court didn't go for that. And we thought these emails were totally damning. We had things like that, like where the journalist herself was uncomfortable with attributing these claims and things like that, but they went for it. And the deposition of the journalist herself was so infuriating. I was watching the video of that, and she just tried to run down the clock, and she was playing the innocent old lady, and she'd be asked a question, and she would do a lot of rolling her eyes, closing her eyes, sitting back for a while, not saying anything, and then eventually looking over to the side, looking over to her legal counsel and saying, "Do I have to answer that?" She was so put out over having to answer these questions at all. And it's just kind of infuriating that I feel like they know they did wrong, and now they know they got away with it. And now anybody knows they can get away with it, I guess, if this is solid precedent.
Well, we also don't want to Streisand affect this, right? You got a bunch of people saying, "Take this down." It draws more attention to it. Like that's the way I always see this stuff. Where it's like this is going to be another one of those things that's going to be forgotten. And there's plenty of hit pieces about. I think all of us, everyone here, Lucian, me, and Matt. There's hit pieces on all of us up there. And the last thing I want to do is draw more attention to any of this stuff and just let it go with the sands of time and fight the next fight. But yeah, it's
Oh,
kind
and
of.
as I've learned too, as soon as somebody like jumps in and says, "No, I know for a fact that that's bullshit," when somebody's accusing me of something, they just brush him off and say, "Oh, that's one of his cultists," you know.
Yeah.
Uh,
Yeah, we automatically don't have credibility because we're not on that, like, puritanical side or what have you.
Yeah, yeah. Well, I guess that's the whole story there. I don't think I really missed anything. I felt like I had hours of stuff to say, but it's like I can only talk for so long in circles announcing my frustration over this. But the facts are what they are, and there's not much you can do with it. And I would rather be talking about us winning in the courtroom. I felt much better talking about the Baphomet case and things like that. But I do feel like when we're handed a loss like this, we do owe people, telling them what the actual facts are beyond a headline saying that we lost a defamation suit regarding sexual abuse and cover up and things like that. I think those do demand us stepping in and giving people the facts of the matter here. We owe that to our general membership and the people who run our congregations and identify with us and certainly aren't engaging in sexual abuse cover up and wouldn't allow any such things to happen. We owe that defense of the organization to the organization broadly. So there you go. I don't know if you guys have any last words on that.
Sounds like that. Yeah, I agree. It's kind of like, well, this is what happened, everybody.
But we keep on keeping on, and you know what I mean? Just like when we first started this thing, I expected a lot more and a lot worse, honestly. Like I came from a real kind of informal expertise about the Satanic Panic. I knew the risks of Satanic Panic accusation. I knew people would do anything to try to defame us and attach us to horrific ideas of terrible things, and people have done it from the beginning. And you know, the worst kind are the kind that sound like they're plausible. Things like this. You have a large organization, the idea of sexual abuse and cover up within a religious organization. It sounds all the more credible when we see, you know, uh, what the Catholic Church has done and other religious organizations, things like that. People don't know how we're structured. They don't know we have this kind of autonomous structure and aren't making these demands upon the congregations and things like that. They don't know our financial setup and that we're not, out there getting money from membership and tithing and startup fees and things like that. So we need to tell them, people are just going to talk their shit, and it's easy to hang accusations on Satanists, but we've we said from the beginning we defend ourselves on these things till the bitter end, and that's what we did here. We brought it through the system the best we could, but we're not going to stop doing what we do, and we're not going to stop defending our place. And with that, that's what it is. Thanks for another lively legal discussion. I'll talk to you next time.